I don't mind being called that, but that is not my name.
Of course.
I originally planned on becoming a chef.
What brought you to this profession?
Desperation and the inability to do maths and the inability to understand science.
So how different you would feel that experience is, the law firm life and this life?
Nepo kid who says that they don't have it easier than first generation lawyers is lying.
Hi Arjun, how are you?
I'm good. How are you?
Doing very well, thank you. So firstly, before going anywhere or proceeding any further, I just want to know what brought you to this profession?
Desperation and the inability to do maths and the inability to understand science brought me to this profession.
Was by any chance, when you came here, did your family history play a part to it? Or
Oh yes, majorly it did. I originally planned on becoming a chef.
oh wow, what did that pivot happen for?
That pivot, I liked cooking, I like eating, simple as that. I wanted to become a chef, but then you think about it and you think about our country and you want to do something which is sustainable. Becoming a chef in India is not for the weak of heart. I mean, becoming a lawyer is also not for the weak of heart, but
No, very true, because I have friends in hotel management. They are definitely either they are doing too preoccupied with life or they're not doing good at all.
yeah.
So I completely understand. One interesting question which comes with family history is Arjun Sir is arguably one of the best at what he does. Very well respected, and all of us have more or less heard of him. So one question that comes, especially when we are aligning first gen or to second gen or third gen advocates, is there a lot of intimidation in your mind to live up to that expectation, or is it a little different from that of first?
First of all, I'm very happy you asked this question because there's this notion that we have it easier, and I will absolutely agree with you. We do have it easier than first generation lawyers. Any nepo kid who says that they don't have it easier than first generation lawyers is lying. But I feel that the toughest battle that someone who is second generation has to face is an internal battle. Because the moment you start telling yourself and you start drawing, I won't say a line of comparison, but you, let's say, start keeping expectations from yourself.
Correct.
That these are the certain boots that I need to fill or certain shoes that I need to fill.
Right.
This is a certain level I need to reach. I think you're making things difficult for yourself. I used to do that for the longest time. It did not make things any easier. So I think for anyone who is second generation, the approach should be very simple. It should be one day at a time. You are definitely going to have it slightly easier. But the expectations from you are going to be higher. People are going to expect that you are going to know things. But at the end of the day, you are also a 24, 25-year-old. So obviously, I don't know any more than a first generation who is 25 years old. But again, that depends from person to person how they carry out their trade.
So it is more about, when you're in a second or third gen, it's more about avoiding the self-sabotage.
It's more about how much you've got to lose. So if you see, if you're in first generation, I feel that you don't have much to lose. What have you got to lose? Nobody knows you. You don't have a reputation to lose.
You're starting from scratch.
Right. But if you're second generation, you don't have your own reputation. But there is a reputation you have to lose.
Uphold the reputation.
Yes, you have to uphold the reputation and at the same time build your own reputation.
Correct.
I'm not saying that is, tougher, but I think that is, slightly different than the journey of a first generation lawyer, because I won't know personally what the journey of a first generation lawyer is like. A lot of my friends are first generation lawyers. I see them struggling, and they've had a much harder time than I do, opportunities wise. And yes, this field is a field which is predominantly
lineage oriented.
Yes, and why not? Because I'm not saying that first generation lawyers shouldn't be given opportunities. Absolutely not. But if you think about it, so many of the senior advocates out there, they started from scratch as well. So they're all success stories.
Correct. So it's like, if I am getting successful, I will want my son to inherit
Exactly.
that.
It's like that.
Of course.
Yeah. So
That's very true. That's very true. So, as you stated, that there is always a big shoe to fill and a perception you have in your own mind. Did that also play a role in choosing what exact sphere or area of law you are interested on?
I personally wanted to try out the life at a law firm.
Okay.
I did want to try out life at a law firm, but then, while in London, things changed. My perception towards that kind of life changed. I don't particularly see eye to eye with that kind of life. I don't want to be answerable to anyone.
True.
I can be accountable for my actions, but I don't want to be answerable to anyone. So it's just a personal choice, I feel. So I feel that, but as far as the shoes, big shoes to fill, it did not have that much of an impact in choosing what I want to do. But as I told you, out of desperation, we do things in life.
Did you, by any chance, have an opportunity to live that law firm life for any small amount of time?
Funnily enough, 90% of all of my internships were at law firms. So,
Oh, wow.
Actually 99%. I think I have just one internship at a chamber. Okay. So, I mean, I had panned out all my internships in such a manner that I wanted to go into a law firm for the longest time.
Right.
But I changed my trajectory at the very last moment. It would have been like I would have been part of probably a dispute resolution team, and the aim was to work at a dispute resolution team in a tier 1 firm and then go from there to, I don't know,
wherever it takes.
Yeah.
In your experience, how, as you said, not just for that one internship you did with an advocate,
Yeah.
but even right now you are living that life. So how different you would feel that experience is, the law firm life and this life?
Oh, very different. Honestly, very different. I won't say that either is easier,
Of course.
but I feel that hours-wise, a counsel's life is much more demanding. A law firm will drain you out within 9 to 5. A counsel's life will equally drain you out throughout the day. The law firm life is more tiring. Within the shorter day, it drains you out. But they don't. There's a notion that that after 5 o'clock you clock out. I mean, I'm pretty sure you might have seen a lot of people working at firms as well. That's not the case.
No, of course not.
But again, I don't think that I work very well in a team structure. I feel that your profession shouldn't be a sport. It's not a team sport. It's not cricket. It's not football. So it's just a personal.
Many times what I've felt is, in these team organizations, a lot of the times either you are doing majority of the work, or if work has come, it's not really that good. So you have to prove it.
I personally feel that more than, that's how it is. As much as your seniority increases, the amount of effort that you put in, literal effort that goes in, should reduce. If you look at it from a counsel's point of view, a senior counsel does not take that much time to settle a draft that a junior advocate takes to draft a petition or a plaint, right? It's the same thing in a firm. The more experience you gather, the amount of effort you put in decreases. But I feel that in a firm that is more scattered, right? How do you put it? The best way to say would be that the delegation of work is very scattered. At least I felt that in Calcutta. How firms operate, I personally don't see eye to eye with how firms operate. They provide me with all the work that I do, so no offense to them, but I just don't see myself ever being a
involved
part
there.
of that organization, because I feel that I would, slow them down. So
Right.
yeah,
You prefer working.
it's not prefer working alone. I don't work alone. That's the major
of course you have
misconception.
people.
Because if you're part of a chamber, you're not working alone, right? You're working in tandem with a lot of people. But I feel like if you are working with a lot of people, you need to be in sync as well. I don't
Of course.
feel that a lot of people in firms are in sync. Very few firms, again, have managed to do that. So I just feel that, that life wasn't for me for these reasons.
Right, and that's ultimately it comes dilutes down to a personal comfort and choice.
Absolutely.
So moving on from the firm perspective,
Yeah.
if I am to rigorate back to academics of your side, you started your journey from Amity.
Yeah.
And thereafter you moved outside to London.
True.
So if you can just map it out, what your perception was.
When I went to Amity, my perception was how fast can I come back home, because I really did not want to go to Amity. Not because, of the common notion, it's Amity, nothing happens there. No. I went to Amity for very simple reasons. I wanted to stay in Calcutta because I wanted to get exposure to work. Simple. I wanted to stay in Calcutta. And that's why I went to Amity. And I didn't crack through CLAT, so that's why I didn't get NUJS, so didn't have the option to go to an NLU. So Amity was the only choice, and Xavier's had just opened up.
Yeah, it was very nascent that you were.
Yeah, because I remember, I think the year I joined Amity, I think that was Xavier's first
or second.
Yeah, 2019. That was, I think, second year for Xavier's. So yeah, so it was still very new. So it was like fine. And one of my dad's juniors, she was from Amity, so I'd spoken to her as to how it was. Okay, fine, we'll go with it. We'll go with the flow, because I'd heard from the very beginning from everyone who is a lawyer. At that point in time, I knew my senior, but not in his capacity as my senior. He had also said, it doesn't matter where you do your degree from. Everyone I ever knew said that. So yeah, I mean, the notion in Amity, even till the last day when I got out of Amity, it was always like, yeah, I don't know what I'm doing.
It just needs to get out.
Yeah, I just need to. I think I started thinking about my career finally in fourth year, when I finally applied at Queen Mary. I applied at Queen Mary in my fourth year. So I think I started thinking about my career actively as to what I want to do. Because see, I applied for my master's. While I applied for my master's, I was still thinking of doing things, from the firm point of view.
Yeah, because till then you were.
I was always, wanting to work in a firm, and but it was always going to be arbitration, irrespective. Now it's like, okay, let me apply. I'd applied to a number of colleges in UK. I'd gotten one from SOAS, Bristol, and then I think Kent, Sheffield, Queen Mary, Edinburgh. But
Edinburgh is also good.
Yeah, I mean, it's very good. But I thought, in London, get the experience. It's a hub of arbitration. So I thought, go to Queen Mary. Yeah, but then I started getting a bit serious about my career fourth year onwards. Whenever I used to even intern at a firm, I think after that I did an internship at Khaitan and Company.
Right.
And I think after that I did an internship at Aquila. I remember I specifically went in there and told them, can I please get to work, and I feel that interns should do this. They should request that I want to have a career in this, but not when you're in your second or third year. When you're in your fourth year, fifth year, you should. That I want to pursue my career in this. Can I get some bit of exposure in this? Yeah, because I want to learn. You're eager to learn, because they're anyway not going to give you the responsibility of the whole brief. So you get to learn. So yeah, and after that, fifth year happened, and I set out for
Queen's Mary.
Yeah, London, and London happened. London was very enlightening, to say the least. It was an eye opener, because when you're with people who at the same level as you don't really realize how poorly you are placed
Place, right.
as far as knowledge and everything goes. But when you're on a global scale, then you're like, oh, I don't know anything.
You see the competition.
Oh, I don't know anything. And I'm not talking about British people, Spanish people, French people. I'm talking about Delhi, talking about Bombay.
Okay.
They would, if you're having a conversation, you can understand that the person in front of you knows that you are not listening to them, but you're hesitant to open your mouth because you don't know. And someone, when you know that someone is able to read that about you, they are confident about their knowledge, and that is, I think, something that is something everyone should aspire to have. It's a quality everyone should aspire to have. If you're talking about something, if you're talking about a subject or talking about anything, should be confident. And if you're listening, that's a different issue. If you're openly, I don't know, I'm willing to learn, that's fine. But if you're pretending, I don't know, let's just nod my head. The person in front of you is not stupid, they will understand. So yeah, you learn your place. I was actually the youngest person at my.
Oh wow!
That was also very strange, because my idea was that you do your bachelor's and then you do your master's and then you get to work. I have this colleague from Queen Mary. He's from Kazakhstan.
Okay.
Yeah, he would party with us. He would go out, hang out with us. He didn't look his age. Suddenly one day I asked him, "How old are you?" 41.
God damn.
Yeah, he's been a partner at a firm for a couple of years in Kazakhstan, and then he's come to do his master. Like, oh, you're 41. Oh, I didn't understand. And a lot of European people, they've worked for 4-5 years. So these are people who are actual professionals. So they are much ahead in the race. And suddenly you're thrown into a race with people, let's say you're in a Maruti 800. There are people, in Audis and BMWs. What do? You can't say, I quit.
Just be patient.
No. Then you realize it's not a race. You just need to get to the finish. You just need to get to the finish line. You just need to stay in your lane. Right. It doesn't matter what car you are in. The car you are in is going to change. During the course of your journey, the car should change. Yeah, if it doesn't change, then we have to quote a certain judge from our High Court, but that's between me and you.
Yeah. So, regarding this very choice that you made, what I wanted to understand, because it's a question of mine as well as a lot of other people, that when we are choosing a college outside, what factors are we to keep in consideration?
I would say the first factor you should keep into consideration is that don't start thinking too early. Because, I feel that if you start thinking about a master's too early, you're thinking with a very narrow mind. Keep a very broad perspective, keep a very open mind, and don't think that, let's say you want to do a master's and you say that I want to do a master's in commercial law or corporate law. But you're not getting a master's in corporate law which suits you. But you get a master's in business law. But you just don't see what the specialization is called, by its name, or what the degree is called. Go into depth as to what the modules are being offered, what subjects you're going to learn, how those subjects are going to help you. So I think that is something you should take into account while choosing a master's degree. Because I was planning on doing a master's in arbitration. I got this course in Queen Mary. It was lucky, but I had also applied for different LLM programs specializing in IPR and everywhere. You keep backup options as well. You might not get the specialization you're looking for. They might not have room.
Should be open.
Yeah, you should always be open-minded, because you might not get the program you're looking
And
for.
also, tell me if I'm wrong, but it's not always your ability, right? There's also a lot of luck involved in whether you're getting a specific
Oh,
choice.
but most definitely, because first of all, they don't. Your marks are the last thing they'll look at.
Okay.
It is important, but it's the last thing they'll look at. Then they look at your statements of purpose. They look at that. But the most important thing is that they have a number, limited number of seats, right? But if they've already received a certain number of applications, and if a certain number of applications have already been, approved, and they can't take you in.
It's a first come, first serve.
Yeah, it's a first come first serve basis. So I think there's a certain element of luck involved to it as well, and timing. So I think you need to be an early bird for that. Yeah, and
Really look into that.
Yeah, be aware. A lot of universities have their open houses here in Calcutta. While before I went, Queen Mary had an open house event. I think it was just before Grand Hotel closed down for maintenance. Yeah, they had.
These things also happen at the park and all.
Yeah. At park also it happens. Yeah, I remember King's College came for their in Marriott. It happened in Marriott.
Right. Also, when we talk about studying outside, the first thing, one of the first thing that comes in mind is scholarships and the money that's going to be involved, because there's a hefty amount that's involved. So I had two things to ask. First is, how big is the money factor, number one, and number two would be, even if we are considering Rhodes Scholarship or Sheving Scholarship, the expenses of living and everything is still not included, right? So what else should be kept in mind?
Firstly, let me clear one doubt. If I'm not to demoralize anyone who might be listening to this or watching this, but a Rhodes Scholarship or a Chevening Scholarship is a 1 in a million.
Exactly, right. Very true.
It's I'm not saying it's impossible, but you have to be, pardon my language, bloody brilliant. And there are better fish in the sea.
Of course.
There are so many people applying. So if you're that confident, great, amazing. I'm happy for you. But if you are really preparing for a master's, you must prepare for a bit of a pocket pinch, because even if they are, exempting the tuition fee, the living cost is going to burn through your pockets, because
a lot.
Because yes, I mean, I can just say it about London. London is expensive, but if you look at the popular destinations for LLMs, for Indian lawyers, I would say one of them is London. The other one is Singapore. You have Switzerland. Switzerland's doing really great, but Switzerland's probably the most expensive European European country. And then you have USA, and USA you'll have problems with visas now, but it's again very expensive. But USA, you'll have a lot of problems with the scholarships, but the tuition fee is extremely high. They might, and they don't give any exemptions on tuition fees, if I'm not wrong. Yeah. So yeah, it's. I mean, on a personal note, I feel that you have to be prepared for a good pocket pinch, because at least it'll set you back by 50 lakh rupees at least.
Okay. And also, one thing that I have noticed when I sometimes look back at the people who have got these scholarships, 90% of the time these are NLUD or NLSIU people. So that the college name also plays a role in that, right? I believe, to a certain extent.
It does. But there's nothing in being an exception to the rule.
Of course.
Yeah.
But that's, again, it comes down to that whole factor of those exceptions in UPSC. Like, one poor child out of millions gets it, and that is promulgated as the ideal, the problem that lies there.
True. Very true. But you have to also see that these candidates who get the scholarships from these NLUs,
exceptionally good,
and if you do place the resume of, let's say, an exceptional candidate from an NLU and an exceptional candidate from, let's say, what is the best private university in India at the moment for law? Probably Jindal.
Jindal, yeah.
Yeah, let's place Jindal, because any other private university, I wouldn't take its name because it can't give you the same amount of international exposure, right? At par, you'll have to see what's the first thing they'll see. They'll see, they'll compare both the candidates and they'll see who requires the scholarship more.
Correct.
Not who's the better candidate. The first criteria as to granting a scholarship is who needs it more.
It's a very great perspective. Yeah.
Because it's not about, oh, it's great if I get a scholarship, onek taka beche jaye. Obviously, but colleges and universities don't give scholarships on that basis. They don't give scholarships just because you deserve it. A lot of students deserve it. There are a lot of great students out there. But it's a lot of international students, and the international student market is a huge business, right? They want international students coming in, right? So, of course, they'll see who wants it, who needs it more. So
that becomes a
definitely.
So you also, after your masters, you also eventually became a member of the Chartered Institute of Arbitrators. Right?
Yeah, I did.
So how did that decision happen? Like, what really cracked your mind to reach that?
Honestly, I was just having conversations with some of my professors back at Queen Mary, Professor Miss Ellis and Professor Fanu. So I was just telling them that, I want to stay in India and build a career in arbitration. But by that time, the decision had been taken that I don't want to be in a firm and want to be an independent practitioner. So they said, that's all right, you can do that. And so many people doing that. They told me that, the good thing is that, you should join the Chartered Institute, and, because for individuals like myself who are, who don't have the, that is a downside, I would say, of individual practitioners. You don't get the networking aspect that firms can provide you with. So, for someone who's, an individual practitioner, that provides you a big platform for, networking with
international connections.
Exactly, with international connections and people who are wanting to do the same thing, right? So, yeah, I mean, I have made a lot of connections due to the, Chartered Institute. It's gone well so far. So, the membership's been helpful. Money well spent.
But that also, just like the masters outside, all of this will include a significant pocket pinch, correct? This whole thing.
Compared to the master's degree, the Chartered Institute is much lesser. It's very affordable. It is very affordable.
Right.
It is not that bad of a pocket pinch. But it is not just, pay and become a member. You have to have certain qualifications, and you have to submit your CV and see whether you're qualified to become a member. Then, there are different grades of memberships. You become an associate member first, then you become a member, then you are elevated to fellowship, then you become a chartered arbitrator. Oh, wow. So there are different stages. Yeah, that's how it happens.
So just to understand, when you reach those levels of chartered arbitrator, are you also given works to be an independent arbitrator in matters international?
You are given opportunities when you become chartered arbitrator status. There are a lot of arbitrations which happen under the umbrella of the ACIArb, and the ACIArb does give opportunities to such, chartered arbitrators. So, yeah, they do.
That's a good exposure holistically.
Yes, of course.
So, as you also as you mentioned your specialties, like the LLM you did and the membership you availed, throughout all this, there's a common link that I find, that is commercial law and arbitration.
Yes.
More or less.
Yes, absolutely.
So, first thing that I wanted to ask you about this is, did this academic regulation that you did, as well as the membership, did they somehow transpire to your practice, or are you doing something which is not really in complete alignment?
See, I'll tell you something very honestly, that if you're a counsel and a junior counsel in India, practicing in India, I feel that you should be a jack of all trades. You should not say no to anything, because it is always great to learn all kinds of matters and how all kinds of laws work, but it is very important as to what kind of chamber you are joining.
Right.
Like my chamber, the chamber that I have joined, that is a chamber which deals with all kinds of briefs, but it's predominantly a commercial chamber.
Right.
A predominantly commercial chamber. So I can apply a bit of my, knowledge that I can't say that I can apply international commercial arbitration on it yet, but
the principles.
Yeah, definitely. I mean, I can proudly say that I can apply my understanding of the competence principle in a matter. Yes, I am competent enough. Horrible joke.
No, it was given the context funny. So even then, one thing that I wanted to understand is commercial law is significantly, when you're looking at the seniors who are practicing,
Right.
the number is less compared to civil and criminal side, I would say.
It's not less. It's just that I feel if you're looking from a Calcutta point of view, I think that since in Calcutta the commercial suits, there's a notion that there are not too many commercial matters. It's a notion, but there are a lot of commercial practitioners. But there are no niche commercial practitioners, like there are in Bombay and Delhi. But there are the fair share of commercial lawyers. But yes, there are a lot of, if you say senior practitioners,
Yes.
who do exclusively practice exclusively sticking to the commercial courts and tribunals. That is true. That is a very, very niche area in Calcutta. Very true.
So when, let's say tomorrow,
Yes.
I want to learn commercial law properly. Let's say I want to have a clear understanding of Companies Act,
Right.
IBC, everything that's there.
Right.
There are two things which come to my mind right now. First is, given the factum that I do not really know as a person how to, or rather in which way I can approach a senior to take me under you as an intern. Is it a better way to just simply visit NCLTs whenever I can, or sit in the courtrooms where commercial?
See, I will tell you this. I used to feel that sitting in courtrooms is is a waste of time, because even up until a couple of years back, I used to think sitting in a courtroom is a waste of time, because I used to understand nothing. I was like, what is happening? I don't know. But the thing is, you don't need to know the facts. You don't need to know what happened in the case. Just listen to the point of law which
Correct.
the lawyer is arguing. Just listen to how, and even if you can't understand the point of law, don't. There is so much to learn in a courtroom. Learn the art of dealing with the judge. Learn the art of dealing with a hostile bench. For even aspiring mooters, it is so useful. I was recently called to a moot court to judge a moot court, and we were given instructions to be a cold bench, to be an ignorant bench.
Okay.
Me and my fellow judge, we ignored that instruction and we chose to be an hostile bench. But the mooters, they had no idea how to tackle a hostile bench. So, and they asked us later on that how are we supposed to tackle a bench, visit courtrooms, see how to tackle, how advocates are doing that, and not just for mooters, but especially for young lawyers as myself. Even when I don't have any work, I still sit in courtrooms.
It gives you a lot of idea about etiquettes.
Definitely, not just etiquette. There is so much to learn. When a senior is arguing, or when any lawyer is arguing, just a point of law, because let's say you have read a certain section of the Contract Act and have understood it as in a certain way, but that lawyer has understood it in a different way, right? So it's just opens up your mind to perspective.
And I think one thing that I learned in the last 7, 8, 9 months I'm here is that it really helped me understand how to structure an argument.
Oh, very true, very true.
Because I've seen the judges take it in a different way. When it's not structured well, their reaction's different, and when you structure it properly,
absolutely, 100%.
So also, like I was saying about the commercial practice area, one thing was about being an intern and how to learn. The second thing would be, whenever I have ever thought or pitched the idea of commercial law, I look in the whole aspect, and it's huge because there's merger and acquisition, there's insolvency, bankruptcy, a lot of things. So firstly, should I try to focus on this one of these particular areas as a specialization? Not saying that I want to practice just on that. Should I focus on one of it as a specialization, or should I try to read all of it?
I feel that you should not focus on any area of specialization. Read, and keep reading. From if you're planning on working as a commercial lawyer, read everything, because no one's going to come to you and, let's say you want to work on an oppression and mismanagement matter and the NCLT it's IBC, right? And they come to you and they're like, this is an IBC matter, oppression mismanagement, you've got this specifically. No one's going to come to you like that, right? So read everything. I feel, I used to feel for a long time that criminal matters I can't do it. I used to avoid criminal law, not because I don't like it, but it's just I feel that it's too difficult for me to understand, and it's still one of my personal weaknesses. But never say no. Never say no.
Even, but one thing that I have seen, especially, and I'm going back to the perspective that you had once, the firm practice.
Okay.
One thing I've noticed is a lot of the tier 1 firm practitioners,
right,
especially the associates, they apparently have these specializations. For example, white collar crime specialist.
That is because that is very simple, because a firm operates at a much larger scale. Right.
That helps you sieving out if you have a specialization.
Yes, because a client will go to a firm with a specific matter. The firm's administration then allocates it to a certain team, right? There are so many teams: team A, team B, team C, right? It's a criminal matter, it goes to team C, it's a criminal team. Then the criminal team chooses, let's go to a criminal law. Is this that difficult? Should we go to a criminal law practicing senior, or do we go to a junior who's practicing everything? Okay, we'll go to a criminal law practicing senior. Then that's how it works. So firms can afford to have that division, because the magnitude of work coming in at a firm is immense compared to that of an individual practitioner, right? So firms are getting 1,000 briefs a day. So they need that division.
So I think, as you very rightly said in the beginning, you really, by your penultimate year, you really need to choose the side you are focusing on, right? Whether a firm or individual practitioner.
I would say yes. And even if you don't, and even if you are confused, you will turn out all right, because it's okay to make a change at the last moment. And even if you work at a firm for, I have seniors who have worked at firms for multiple years and are doing really well in litigation. I have also got seniors who have worked in litigation for a number of years and have now shifted to firms. They are doing very well. So there's a very poor notion, if any, that you cannot shift at any point of time. You can also shift. Do whatever pleases you and what type of work pleases you.
So in this pivoting part, I had a small but personal question.
Yeah.
So which is, in your opinion, do you feel for a first generation as compared to someone who has people in the family, is it a more difficult choice to make a pivot? Because they, in my perspective, they do not have something to fall back on.
I'll give you a very simple answer. It's not necessarily, you don't need anything to fall back on.
Okay.
But more than falling back on, I personally feel that the choice between litigation, if you're if you're already not decided and if there's a confusion, I think the choice between litigation and working, or rather choice between working as a counsel and working at a firm boils down to one very simple aspect. There is a need for money.
Of course.
Yeah. Now, at least in Calcutta. So, in the initial years, they call it the deviling period for advocates. It is difficult for juniors. It is very difficult because you don't get paid well. Sometimes not at all. But it's just that way. But at firms, you get a steady payment. Now, the issue, however, is that you get paid, but then there is a certain ceiling, right? But for a counsel, they say it's a long run. It's a long run game. It's a long time investment. Now, I feel that if you are not clear as to which choice you're making, it's not about what to fall back on. If you feel that, for those first 5 to 6 years, with you not earning, if your family or if your surroundings are going to be all right with you not earning, then, go for it. Take the risk. Why not? But if that doesn't suit you and if you're in need of a steady income, then I think the firm life is much more suited.
And do you think the vice versa works as that well? In the sense, I'm doing individual practice
Right.
for 5-6 years. Then I choose to join as a senior associate somewhere after 7 years of practice.
There are a lot of people who have not enjoyed the counsel life, just not enjoyed the counsel life. I'm not saying that they haven't earned money.
Of course.
They've not enjoyed the life, and they have, and that has worked well for them.
Goes both ways.
Yes, of course it does. Of course it does.
In the last few aspects,
Yes.
if I'm getting down to your niche area, which is arbitration.
Okay.
So I wanted to ask, firstly, that arbitration inherently had 2-3 factors in its inception. One is that it will be an out-of-court factor going on,
Right.
which will reduce the burden of courts.
Right.
It will be, to a certain extent, a reduction of the court expenditure
Right.
that you are supposed to be incurring in the court for the long process.
Right.
And that it will allow for a faster redressal.
Right.
So, keeping these factors in mind, how do you think, as of today, India's arbitration hub has fared out?
Quite well, actually. Quite well. But I just feel, see, if you think about a lot of people have the notion that, there's a lot of court interference in India's.
Like Section 9 is there and all
those things are there. But, I think if you have a look at the 2025 English Arbitration Act, then you'll understand what actual court interference means. So if you just for comparison, so that is proper court interference. But I think Indian laws are very lenient when it comes to court interference and arbitration proceedings. But again, from a very, a very humble standpoint, I feel that, arbitration in India has done very well for itself and it will keep on growing. But the only fear, or rather skepticism, that I have is that it should not fall behind the other forms of dispute redressal just because of its slow pace.
Okay.
Yeah, people should not, I'm not saying that mediation is not effective. I'm not saying that conciliation is not effective. But, situations, the situations and circumstances might require arbitration at times. So I just hope that, arbitration doesn't fall behind, and I don't think it ever will. But, sometimes the paces of the pace at which some arbitrations run is extremely slow. And I think that is a culture which needs to change in some places in India.
Do you think this is, it's again your personal opinion, do you think it's because mostly right now the independent arbitrators who are appointed are senior counsels?
No, not because they're senior counsels, but I think because of India's inherent colonial hangover.
Right, the court practice mindset that's there for
So the court
extending it.
practice mindset has always been there, and it's always going to be there, and it should be like that,
Right.
because that is what sets us apart from other nations, and that is what sets our judiciary apart. Then that's fine. But arbitration was always supposed to be out of court, and it wasn't supposed to be, a court proceeding, right? So I feel it shouldn't be treated as one. When you're doing a section 9, when you're doing a section 11, that's fine. That is absolutely all right. But I feel that arbitrations should be treated as formal out of court settlements rather than, out of court proceedings. They're treated as out of court proceedings. I just find that a bit awkward.
Right. And also arbitration in India,
Yes.
maybe it's also because of my less known idea about it. I have seen most of them are quite hefty in expenditure. Do you think that really serves the purpose of arbitration when it's not?
If you think about it, an arbitration will get you relief within 1 to 1.5 years, right? A long run litigation will get you relief within 15 to 16 years. You're anyway going to end up spending 15 times more money on litigation. So it might seem like a lot of money, but on the time, on the time saving aspect, you're actually saving a lot of money. And I mean, you're saving a lot of money. And yes, I mean, the fact that, a lot of money is spent, but you also have to see the costs of these arbitrations, the cost of the money involved, and these are huge magnitudes of money and huge contracts, right? So I think that the costs involving these arbitrations is very nominal when it comes to that.
Right. And also, many arbitrations happen where, let's say, one party is a PSU,
Right.
and the other party is a private contractor or whatever be the So while this appointment of independent arbitrator takes place, do you feel like India has enough safeguards for that?
Yeah, of course it does.
And is it implemented? That is the most
No, definitely it does, because you see, you first under Section 21. Now, if your Section 21 is rejected, then what do you do? You know what we do?
No, not really.
Section 21 is for appointment of an arbitrator, right? Notice for appointment of invocation of arbitration proceedings, right? Now, Section 11, right, is for court-appointed arbitrator.
Correct.
Now, the court appoints an arbitrator. So, see, where we have provisions for the court to appoint an arbitrator, I think there is enough safeguard therein. So, there's no, if that's what you're asking, if I'm understanding you correctly, that, there are enough safeguards in appointing arbitrators and appointing tribunals, because tribunals are appointed very easily, because I appoint one arbitrator, you appoint one more, they appoint the third guy, so there's no scope of bias there.
So given arbitration is a subject matter where experts exist, and like you said, there's even the chartered arbitrators of ACIArb.
Right.
So in your opinion, do you feel like it would be better for arbitration if these experts are empaneled to arbitrations rather than who are doing currently, or the people who are right now doing it should have that culture inculcated?
No, I think a mix of both these cultures is required, because currently in India there's a lack of governance of institutional arbitration. There's a lack. And I think India needs that, and appointment of arbitration professionals as arbitrators is necessary. But at the same time, if you see that, retired judges are appointed as arbitrators,
Correct.
These are people with, years of experience in adjudicating such matters with such gravitas. So I think, you can't go wrong with these people either. So I think a mix of these cultures, both these cultures existing in tandem would be better for the, growth of arbitration in India. I think institutional arbitration, if woven into India's current arbitration framework, could go a long way.
That's right. No, tell me if you're...
Yeah, as a matter of fact, a lot of juniors nowadays have been suggesting such ideas to me. So
that, no, I think it's, in a way, it's pretty good. And for you also,
yeah,
when you eventually be member of the places you are currently in, it will also help you as well as people who are actually spending significant time and years in understanding arbitration as a whole.
true. But just one thing to clarify, I think, if you want to build a career in arbitration, becoming a member at these places does not help in, increasing your understanding of arbitration. Reading the law, reading how arbitrations are happening, reading awards, passed in different arbitrations worldwide, that increases your knowledge of arbitration. They pick up Redfern and Hunter, pick up Gary Bourne, pick up Lucas Mistelis on arbitration as well.
We need to be noting these books, by the way.
So, yeah, I think you just need to read and learn. But what these memberships do, they just give you a platform for networking and finding the same kind of people with similar interests. Because, it's still such a growing market. And since this is not just limited to one high court, right? It's a whole world. So you can't be in the, Delhi High Court and the Calcutta High Court at the same time, right? So it's just...
So growth is personal, the outreach has to be massive.
Yes.
You said a very important thing which I almost missed out. Arbitral award.
Yeah.
So I want to understand that as you have read through arbitration and understood to it to a certain extent, what would you say is an ideal award? Because what I have seen is a lot of awards are like 50, 100 pages long.
I would refrain from answering this question because I am in no capacity to say what a perfect award is. I'll just say this: if you're appearing in an arbitration, an award is whatever. A perfect award is whatever get my clients the relief. That is the perfect award for me.
Because nonetheless, it is going to be challenging.
Yes, because but in the way that you wanted me to answer this question, I cannot give you that answer right now. Maybe in 20 years' time, you ask me this question again, I will give you the answer.
Noted, done. So at the very end, I just have two questions to ask.
Yeah.
First is, if tomorrow I am to join you.
Don't.
If hypothetically you are 40 and I am still 22 and I am to join you.
Why do I need to be hypothetically 40?
So that you become senior.
Okay.
And I join you.
Okay.
What would the requirements in your mind be for someone who's joining in essentially a commercial area of practice?
Just need to have an open mind and be willing to learn. And one more thing, you should, just be willing to, for today's generation, I think the term is to grind.
Okay. And is there any specific statutes that you would like them to have at least a compact idea about, like a solid idea of?
Since all our colleges are very book oriented and they give us a list of books, you want me to do the same. I don't like being restricted by books, but okay. If you just commercial, you should know about the Contract Act, the Companies Act, the old one and the new one, the IBC, the Commercial Codes Act, everything, everything under the sun relating to commercial. Don't go and read the Mines Act.
Of course.
But again, I was required to read the Mines Act as well. But okay.
That's why you connected it.
Yeah.
And last, I would want you to tell all our viewers that if or when they are willing to pursue, let's say, commercial litigation, or before that willing to go outside for studying about commercial law, what would be your suggestion? Like, let's say the concluding 2-3 lines that you would like to tell them.
Concluding 2-3 lines. Be prepared for a lot of disappointment. Be prepared for a lot of heartbreak. Be prepared for a lot of, despair and depression. But in the end, it will work out.
Perfect. Thank you so much.
Yeah.
Thank you so much, everyone. We really hope that today's episode helps you understand and get a strong grasp of what is really required to pursue litigation, firstly, the differences between a first gen and second gen and the perspectives thereby, and also if you are willing to take any lessons in arbitration thereafter, or if you want to pursue academics from outside, that is London or Singapore, what are the things you should keep in mind. So with this, we sincerely thank our speaker today, Mr. Arjun Ray, and hope that you enjoy today's episode, and we really hope that all the next episodes to come are also as fruitful as this one to you. Thank you.